Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Welcome to our Curious Amalgam. I'm Alicia Downey, and the title of today's episode is Are PBMs Good for Competition? A cost-benefit analysis of the effects of regulating pharmacy benefit managers. In the past few decades, pharmacy benefit managers, or PBMs, have emerged as key players in the incredibly complex U.S. healthcare industry, along with drug manufacturers, health insurance companies, and pharmacists. PBMs are intermediaries in a prescription drug supply chain that starts with the manufacturer and ends with the patient. In recent years, critics have called PBMs out for negotiating allegedly unfair and anti-competitive contract terms that supposedly drive drug prices up while providing few consumer benefits. Indeed, the FTC is in the midst of a wide-ranging investigation into whether certain practices by PBMs may violate the antitrust laws. Today, we'll be speaking with an economist about what his research indicates may be the potential unintended consequences of forcing PBMs to change their behavior, whether through legislative means or enforcement proceedings. My co-host today is Jeny Maier. Hi, Jeny.
Alicia, so happy to be here.
Jeny, would you like to introduce our guest and kick off the conversation?
Absolutely. I'm looking forward to this one. Our guest today is Professor Casey Mulligan, a professor of economics and also the program director of the Initiative on Enabling Choice and Competition in Healthcare at the University of Chicago. In addition to his tenure as a professor at Chicago, Professor Mulligan also served as the chief economist of the White House Council of Economic Advisors in 2018 and 2019. And he has published extensively on regulatory economics, including healthcare regulation. So welcome to our Curious Amalgam, Professor Mulligan.
Hi, Jeny. Hi, Alicia.
Well, thanks, Casey. As listeners of this program, and indeed many people who've been following the news over the last few years, know that high drug prices are a perennial political hot topic. The Biden administration and the Trump administration before that, along with Congress, have tried to push forward different policies and regulations to try to address this perennial problematic issue. In recent months, PBMs have been under the microscope for their role in the drug supply chain and their influence on drug prices. In February of this year, you provided testimony to a Senate committee that was considering a piece of legislation that would have restricted PBMs from engaging in certain practices when they're managing the benefits for a health plan. Could you explain a little bit to us about that proposed legislation and what were the nature of the restrictions on PBMs that was at issue in this legislation?
It was called the Transparency Act. It wasn't passed yet, but that was the name they gave it. A lot of what was in there was not related to transparency. What they mean by transparency in the parts of the bill that dealt with that would be disclosure of the contractual terms among the various parties in the drug supply chain, particularly those dealing with PBMs, which includes health plans, manufacturers, and retail pharmacies. But they were also had price controls in those that bill that would restrict what could be charged between the different parties in the supply chain.
And in your testimony to the Senate, you had outlined some of the direct as well as potentially indirect benefits that PBMs offer to the broader healthcare market. Could you outline some of those benefits for us?
Yeah, the prescription drug market has a couple different functions that go on. Some are maybe more obvious, like manufacturing. The drug needs to be, first of all, invented, then manufactured. And there's the retailing, like so many products, the consumer likes to deal with a retailer maybe near their home rather than traveling to the manufacturer, which may be in another country. So you have those two elements. And there's a question of the degree of competition among manufacturers for the manufacturing part of the industry. There's a question of how much competition is there among retail pharmacies on that side of it, especially since it tends to be very localized. And one function that PBMs do, and they weren't put in there by government to do this, they emerged organically in the marketplace, was to encourage competition among manufacturers. They serve as a buyer's club to buy drugs from manufacturers. They also serve as a buyer club among retail pharmacies. So buyers get together. Often those buyers are members of the same health plan, but typically multiple health plans are represented in these negotiations by a PBM. And so they act as a buyer's club, and they've been very successful at securing lower prices from the manufacturers on the behalf of their buyers. They're kind of like a Costco. And they've been very successful at getting lower prices for the retail part of the duties that are needed in this industry.
And maybe without going into the specifics of the bill that you were testifying about at the hearing, speaking from your position as an economist and a professor, what are some of the economic principles that you would keep in mind as you're evaluating the costs and the benefits of regulating entities like PBMs?
I think one of the mistakes that's made, again, in many industries, they see a part of the industry that they think is not competitive. Maybe they're right or wrong. We can put that for a later discussion. But then the way to deal with it is to punish those companies who are not competitive enough. And that is not helping the problem. If you're punishing the sellers of whatever it may be, say these buyers club services, you're not encouraging companies to get into the buyers club business. And that's what competition is. The threat or the actuality of companies getting into the business. And one of the problems with that Transparency Act and many of its regulations, they were kind of motivated about punishing the PBMs. And go ahead, punish them. I mean, maybe that's justice in some sense, but it's going to make the consumers pay more. Whether you have a monopolist, an oligopolist, or a competitive industry, you add costs to the sellers. The buyers are going to experience some of those costs, if not all the costs. So that's a principle we need to understand. It doesn't mean policy has no role, but the policy role should not be a punishment role. If you care about the consumer, the role really should be encouraging competition, reducing entry barriers, making it easier for companies to get in there and compete for whatever it may be, like being a buyer's club. And that was another problem I had with the Transparency Act and some of these other regulations. They weren't even evaluated from that perspective. And typically, when you do evaluate them, you see that these regulations actually favor the bigger PBMs over the smaller ones. So it's really, if there's a competition problem, it's making it worse.
How do they do that? How do they favor the larger ones who I think, seem to be the targets of so much criticism versus smaller PBMs?
Yeah. Now, again, this is common in economic regulation. The so-called targets end up being the beneficiaries or maybe the least harmed by the targeting. But most of the regulations have some kind of restriction about how the benefit manager can deal with the health plan or how the benefit manager can deal with the retail pharmacy. And this is less of an issue for the bigger ones because the bigger ones have their own health plan. They have their own retail pharmacy. So this is like telling how the right hand can deal with the left hand. It's easier to adapt to. And there was actually a Nobel Prize in economics won on this topic by Oliver Williamson, who said, well, if you're going to regulate transactions among firms, you're going to favor the vertically integrated business models over the less vertically integrated models. And that's where your smaller PBMs would not have their own health plan, would not have their own retail pharmacy. And so they're going to really bear the brunt of these restrictions because it's going to restrict what they can charge, how they can deal with these different parties. and it's not their left hand talking to their right hand.
And when you were testifying before the Senate committee, you were very critical of these disclosure requirements that were being contemplated, requiring PBMs to disclose certain, information about rebates and other relationships with drug manufacturers. And in your testimony and your remarks, you've suggested that complying with those particular requirements would in and of themselves raise some antitrust concerns. Could you walk us through that thought that you had?
Yeah, there's a couple aspects of it. One is what we just talked about, that asking the vertically integrated companies to disclose how their left hand's paying their right hand, they can basically make it up, because what does it mean? It's really all window dressing in that case. Whereas asking the smaller PBMs to disclose how they deal with pharmacies and health plans and manufacturers, these are real transactions with real money that they're revealing. So that's a problem, undermining competition in that direction. Another problem, which the FTC has raised over the years, they have different leadership, but I still think the rank and file believes this, that by revealing these private transactions, you're undermining competition. Because now the manufacturers know exactly what number they need to beat, and they won't go any lower than their competitor has done, because it's all become public. In fact, the new leadership at FTC, I think, has even gotten stronger on that point and said, while previous FTCs have said, we want to be careful, let's not have it too disaggregated information, I think the newer FTC is saying, we're not sure we want any of this information out there. So there's that angle. Then the third angle is that PBM is unique in that they're not a manufacturer, they're not making a chemical, they are not a retailer, they don't have a storefront. They're a business model. That's their innovation, and they've been very innovative in that. And now you're asking them to reveal their trade secrets, their proprietary. I'm not a lawyer, so I'm sorry if I'm using terms of art in your field. I don't mean it that way, but you're asking them to reveal really how they do what they do to their competitors, and that's going to hurt incentives to create new business models, because if you create one that can help your clients, you're going to have to share it with all your competitors. So you have those three anti-competitive elements going on.
Now, I'm just going to quote from a recent FTC press release, because I referenced this investigation into PBMs that the Federal Trade Commission has been undertaking for the past several months. And in this press release, the commission lists what it's looking at in its investigation as follows: charging fees and clawbacks to unaffiliated pharmacies, steering patients toward PBM-owned pharmacies, potentially unfair auditing of unaffiliated pharmacies, the use of complicated and opaque pharmacy reimbursement methods, and negotiating rebates and fees with drug manufacturers that may skew the formulary incentives and impact the costs of prescription drugs to payers and patients. So that's what the FTC is looking at. Is there anything in the Transparency Act that converges on, addresses those concerns, or are these two separate initiatives?
A couple of them are in there. Actually, a lot of the Transparency Act is giving more money and power to the FTC, which undermined it in the eyes of a number of the members there. But I think you mentioned the opaqueness of the transactions. The Transparency Act, by its title, is intended to improve that, if we can call it an improvement. Again, I stated why that might be a problem for consumers. You also mentioned the clawbacks. Again, those have to do with the ways that the different parties pay each other. And the Transparency Act had several restrictions around how the different parties can pay each other. And
so would you say, though, that at least from the consumer standpoint, using economic analysis, because you're not a lawyer, I'm not going to ask you to render a legal opinion, do you think there could be some antitrust concerns with the behavior, at least as it's described? Well,
the steering to your own pharmacy, again, this is not something unique to prescription industry. In industries in general, where there's vertical integration, there are concerns about that. Not all the concerns are legitimate, but it's something to look at. Those others I don't view as concerning at all. I would point out that I believe it was the Department of Justice. It was before my time. Early on, PBM is a fairly new thing, maybe in the 80s or so. And early at that time, there were some manufacturers who had their own PBM. And some people maybe had argued that the first PBMs were from the manufacturers. And DOJ pretty early said, no, we're not going to allow the manufacturers to own a PBM. But I certainly have a lot of respect for that concern that the seller would own the buyer's club, in effect. Because the manufacturer is a seller and the PBM is a buyer's club. And if they're one and the same, that could be an antitrust concern, because the buyer's club is pro-competitive. The PBMs are promoting competition among manufacturers and among retail pharmacies. And what would be sad for the consumer, maybe happy for the manufacturers and the retailers, would be if trying to add a little competition among PBMs, you end up undermining competition among manufacturers and undermining competition among retailers.
But with so many people pointing the finger at PBMs as the villains and perhaps the cause of higher drug prices, that is, the prices experienced by patients, either whether in the form of their copay or parts not covered by insurance, do you think that that's a misdirected accusation?
Yeah, I would be stronger and say that it's fake news. That the idea that the PBMs raise what the patient pays. I mean, this is a common refrain, and it's very wrong. When the PBMs deal with the manufacturers, it's part of a contract. And we all pay attention to the rebate, the kind of the price side of the thing. The PBMs are getting a lower price. And they are. That's part of the contract. But I'm sure this audience knows very well, contracts are not just one clause. There's another clause for the other party. And what does the PBM have to do? Well, the PBM has to either achieve some sales targets for the manufacturer or take steps that everyone agrees will help the manufacturer achieve sales targets. And typically what they do is, number one, include it in the formulary. So manufacturers say, 20% rebate for you, but I got to be in your formulary. Okay, that saves the patient a lot of money. The patient saves, instead of paying the full list price, which would happen if they weren't covered, they're going to pay 25%. So they're saving 75% just from there. The other thing that they'll do is they'll say, instead of 20% rebate, PBM, put me in a lower price tier and we'll give you a 30% rebate. And that, again, saves the patient money. So I know even maybe past episodes of this podcast have made the claim that PBMs do not pass on the rebates to the patient at the counter. That's not true. In fact, they pass on more than 100% of the rebate when you understand the rebate as part of a contract.
Then do you agree that drug prices, that the issue of sort of the levels of certain drug prices is one that you could characterize as a problem? And if you do agree, what do you think is the correct path to addressing that problem?
Yeah, I think you mentioned I'm the director of the Center for Choice and Competition. So choice and competition were things that I'd point to, and I think your listeners are interested in, at least in the competition side of it. Competition. And this is something we've known, Congress has known for years, that the government itself is very much a barrier to competition. Specifically, although not only, the Food and Drug Administration has been a barrier to competition. And Congress repeatedly passed laws and said, FDA, get out of the way, get out of the way. FDA flouted those laws. They had all kinds of excuses why they weren't doing what Congress told them to do in the statutes. And one thing that President Trump did is put in an FDA director, Scott Gottlieb, who really did get the FDA out of the way. And he had a bunch of new manufacturers enter the prescription industry. You saw manufacturer profits fall, and you saw drug prices fall for the first time in 46 years. So drug prices were going up faster than inflation for many, many, many years. That's old news. That stopped in 2018, and drug prices have been falling in absolute terms and certainly growing less than inflation since then. And it's very easy to point to a major factor in that, which was increased competition. There's plenty of room for more competition. There's more. The government is still in the way in many things. President Biden, when he came in, reversed some of President Trump's deregulation around that, allowed the FDA to act as more as of a barrier than President Trump was allowing them. So drug prices can come down more. And as an economist, we know how to do that. I'm not a politician. I don't know how to get it passed in Congress. I don't know how to win the elections, but the economic side is fairly clear.
That's going to be a continuing story, I'm sure, for the next, what you said, PBMs have been around for a couple of decades. I think we'll be working on this problem for a couple of decades more. For those who are interested in learning more about this issue, we'll be posting on the webpage of this episode Casey Mulligan's op-ed article from the Wall Street Journal, as well as the transcript of his testimony before the Senate and some other goodies as well. And thank you very much for a very interesting conversation. Before we let you go, however, we're going to ask you the question we ask all of our guests to try to get to know them a little bit better as human beings. And the question is, what is something interesting about yourself that's completely outside of your professional life?
Well, a lot of people are surprised to hear that I went to a Catholic military school for high school. And it's not because I was a wayward child and had to be sent away. It was a lot of fun. Learned a lot of discipline. I think they told us if we were late for class, we had to do a push-up for every second that we were late. So I'm not late for things. Was I late for this today? I don't think so.
No, you're not. And you appear to be in very, very good shape, although maybe that's just a reflection.
My arms got no work. My arms got no work because I was always on time.
You were a good boy. All right. Yes. The other thing we'll do with you is play a little game that we call the Curious Hat.
And now it's time for the Curious Hat.
The rules of the game could not be more simple. Jeny will draw a completely imaginary number from a completely imaginary hat and read you the surprise question that corresponds to that number. Jeny, take it away. Something different.
Question number 5. If you could have front row tickets to any performance, musical, theater, or otherwise, what would you like to see?
I like the Hamilton a lot. And I like concerts too, but the front row would be too loud. So I would say I would want to go to Hamilton again and sit in the front row.
Excellent.
Yeah, I want that too. That would be great.
Solid choice.
Yeah. Well, thank you so much. Thank you, Jeny, also for joining us today. Thank you to listeners, and tune in to our Curious Amalgam next week.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.